Number 42, the people of the state of New York versus Kerri Roberts. Counsel?
May it please the court, Philip Morrow for the people. I'd like to reserve 2 minutes of rebuttal time, please.
Yes, sir.
This case provides a perfect example of the type of conduct that the legislature intended to target when it enacted the identity theft statutes. Defendant used someone else's credit card account number to try and purchase more than $1,000 worth of sneakers and hats. Defendant's effort to defraud the victim did not depend upon his using the victim's name. Instead, the key to defendant's scheme was his having obtained the victim's personal identifying information, in this instance, her credit card account number.
So, counsel, let me ask you, your interpretation and your construction of this statute, what, if anything, does assumes the identity of another person add to the statutory provision?
That phrase doesn't change the way that the statute is applied, but it provides a definition for what it means to assume someone's identity within the meaning of the identity theft statutes. This was a new crime that the legislature was addressing. It wasn't in existence before these statutes.
But taking somebody else's credit card number and using it before the identity theft statute was still a crime, no?
It was still a crime. It would likely be covered.
So I'm wondering about how you started by saying this is exactly an example of what the legislature was trying to attack through this new statute. I mean, is that right, really? It's just taking somebody's credit card number and using it to buy sneakers?
If you look at the legislative history that's cited in our brief, the legislature was concerned by the massive amounts of consumers' public identifying information that was being stored on servers and was being accessed by criminals to
buy sneakers?
Well, to buy sneakers, to open credit, to do all sorts of things. And the big difference between the identity theft statutes and criminal impersonation is that you don't have to engage in acts of impersonation that would cause another person to think that you are that particular person. Because with the criminal impersonation statutes, there's a requirement that you deceive or you convince another person. And here, if you take someone's credit card number and you don't say that you are that person, it might not be covered by the criminal impersonation statutes. So it's a different type of conduct that they intended to target. And as the Fourth Department has recognized.
But I'm still not clear. I see what you're saying, but I'm still not clear, given that the statute says you're guilty of identity theft, why this other language, based on your construction, right, the assumption of the identity of another, isn't superfluous.
Well, it provides a definition for what it means to assume the identity in the context.
But what I'm saying is, why does one need that?
Because the legislature was defining identity theft, and as the decisions from the First Department indicate, there's a common assumption of what it might mean for a person to assume the identity of another.
I thought the core of your argument was that there are three specific instances or three specific acts that are set out: presenting yourself as another person, acting as another person, or using that other person's personal ID, and that those acts themselves, when you perform those acts, mean that you have assumed the identity of that person.
That's correct.
That's the way I understood your argument. The problem with that is the common sense of what assumption of identity would be. I give my wife my check and I say, would you deposit that for me? I'm going to be in Albany for a week. And when people still got checks, but in that instance, would she be assuming the identity?
She would be assuming the identity, but I think...
Would that be distinct from breaking 19080 of the penal law, breaking that particular law?
It would not be identity theft, because if
Is that because of intent?
She would not have the intent to defraud.
So then wouldn't that make assuming the identity a separate element?
But it doesn't make it a separate element. It provides you have to do one of the three acts alone is an element of the crime. You don't have to, based on the statutory construction, you don't have to use another person's personal identifying information and present yourself as that person or act as that person. If that was what the legislature wanted to do, it could have written the statutes in a way that achieved that, but it avoided that and treated each of the three methods equally. There's no...
True, but isn't presenting yourself as that person or acting as that person the same as assuming the identity of that person? So again, I'm not understanding how you get around this language is superfluous under your construction.
Well, presenting yourself or acting as yourself are examples under the common understanding of the term of what it would mean to assume the other person's identity, but the legislature was targeting a new type of crime that's based on personal identifying information. And here, as the facts of this case illustrate, defendant knew that he didn't need to say that he was Kelly from Moyle, the victim in this case. The key was that he had her credit card number. And when he was interacting
But all I'm
with-
saying is, under your construction, you don't need assumes the identity, right? Would not, under your construction, his conduct have violated the statute if you don't have assumes the identity of another person?
Yes, it doesn't change the application of the statute. It provides a definition for a new term. And I think that, what we have here is there's a
The new term being identity theft?
Well, identity theft is the overall crime, but what it means to assume the identity of another person. Because like other statutes in the penal law, if you talk to someone on the street, they would think a burglary is someone going into a house at night and stealing things. But as we know from the penal law, burglary can be a lot of things that don't fit that common understanding.
But if that was the case, wouldn't assumes the identity of another person precede, using personal ID information?
When it,
Since presenting yourself or acting as the other person is assuming the identity of someone?
would it,
Wouldn't
precede it-
the legislature have simply taken the phrase that I'm asking you about and put it before the personal ID? Because that's the one that I thought you were arguing, that's the one that perhaps is not so obvious.
Well, I think that they wanted to make sure that this would be, the use of personal identifying information would fall within the statute, that there was no need to deceive. So it set it out very clearly that this is a way that, under the statutory meaning, you can assume the identity of another person.
Counsel, maybe I'm wrong, and maybe I'm just not following this back and forth, but I thought your argument is, assume the identity of another person can be done by any of those, I think it's 3 ways that are listed beyond that, right? You can do it by this, or by that, right?
Yes.
And I think it's hard to read this statute where it says you can do that by acting as that other person, right? Or by presenting himself or herself as that other person. And how can you assume the identity? What could assume the identity mean if it doesn't mean one of those 3 things?
Well,
I
I
guess
don't
that's
think,
a question for your adversary here, but I'm having some trouble understanding what it could possibly mean other than those 3 things.
I think you're correct. I don't think it's possible to engage in conduct that would constitute.
To follow up on that, on Judge Garcia's question, could the statute have been written, and this is when I was reading it, I was thinking this, could the statute have been written without the phrase assuming the identity or assumes the identity?
As I said to Judge Rivera, it could be, the application of the statute wouldn't change by taking out that language, but it was providing a definition. And I think in contrast, the interpretation by the first department renders the use of personal identifying information prong superfluous, because in order to assume the identity under their interpretation, you'd also have to act as the other person or present yourself as the other person. So that language in the statute would have no meaning. And that was clearly something that the legislature intended to target here.
Well, let's say we agree with you about that. But we also think that your construction, again, leaves us with parts of this statute that seem superfluous. What do the canons of construction tell us to do in that case?
Well, the canons of construction, you look at first the text of the statute, then the statutory scheme, and then the legislative history. And applying all those things together, it's clear that the legislature was concerned about this type of crime. If you look at the other statutes that were enacted at the same time, they wanted to have a very broad definition of personal identifying information, of what it means to be a victim of this crime.
So what you're saying is that there's no ambiguity here?
No, there's no ambiguity. The statutes could have been written in a way that forecloses some of the challenges made to the statute, but there's no ambiguity in this provision of the statute. As the Fourth Department recognized, you do any one of the 3 things, you've assumed the identity of another person under the statute. I see my time is up, so.
Thank you, counsel. Counsel?
Yes. Good afternoon, Your Honors, and may it please the Court. My name is John Vang, and I represent the defendant, Kerri Roberts. The problem with the people's interpretation is that it would permit prosecution for certain kinds of conduct as identity theft that don't advance legislative intent. We look simply at the statute at 190.
Like what?
19077 defines personal identifying information, Your Honor. It includes things like an address, a telephone number, a place of employment.
But you have to have a fraudulent intent. You have to have an intent to commit a crime, to obtain goods or something like that. So it's not just the innocent, I mean, we deposit each other's checks and things all the time, but that's not what the statute is prohibiting.
Let's say someone lives in New Jersey and then wants to use grandma's address in Queens because they want to have their child attend one of the major New York City high schools, right? They're using grandmother's address. They're disavowing grandma's identity. However, under the people's interpretation, the mere use of an address would automatically result in the assumption of grandma's identity. Same thing for a telephone number. Let's say someone uses the telephone number for this Court of Appeals hall. Under the people's interpretation, the mere use of that telephone number, which is defined as personal identifying information under 19077, would automatically result in the assumption of the identity.
But that doesn't mean they're guilty of a crime. I think their point was, yes, technically you would be assuming the identity, but you still need the intent to commit the crime to be guilty under the statute. So that's kind of, yeah, they would be, but what's the result?
The intent to defraud, in this instance of the example of the person who lives in New Jersey and is trying to use grandmother's address, the intent to defraud modifies the conduct, which includes, assumes the identity of another, as well as using personal identifying information of another. The intent to defraud could be intending to defraud the city of New York. That might be a crime in certain instances.
So then if it was an assumption of an identity with an intention to defraud, then yes, it would be a crime. But I don't understand what the problem with that is.
The problem is that the purpose of the identity theft statute was to prosecute certain kinds of crimes that were resulting in damaged reputations, damages to credit reports, those kinds of things. The legislature then
like
defined,
using someone else's
but I'm referring
credit
to 19077. 19077 defines personal identifying information. That's a critical point. In that statute, it lists over 20 types of identifying information, some of which on its own, if used, could automatically result in the assumption of another person's identity.
Well,
but it also,
let
go
me
ahead.
ask you this. When we look at a statute, we look for symmetry and how it's constructed. And here, it says, assumes the identity of another person by presenting himself or herself, by acting as another person, or, and I'm sorry, they're all or by using personal identifying information. How could the third thing be treated differently under this statute from the first two things?
I think that's the problem with this statute, Your Honor. And I think what the legislature did,
what's the
including
problem?
the
It's
problem is that
clear.
it's in the interpretation of the statute, consistent with the people's interpretation, would result in prosecutions that don't advance legislative intent. Legislative intent needs to guide this court's interpretation of a statute. And again, I asked the court, look at 19077. It sweeps in a broad array of types of personal identifying information, which, if used on its own, would not
But the
result in
legislature knew that. When they passed this law, they knew what those definitions were. They included the term here. They added an intent to defraud. But it seems your argument is we should read it so that despite what they did, and the clear language, I think, of this statute, it doesn't advance what they were trying to do.
It's not what despite. I think it's simple. Look, let me use another example of a credit card number. Let's say someone uses a credit card number but disavows the identity of the person. Under the people's interpretation, the person has used a credit card number, and on its own, that will have resulted in the assumption of that person's identity or the commission of the offense. But that cannot be the case if they disavow their identity.
Wait. It results in the assumption of the identity. It doesn't result in being guilty of the offense because you still need an intent to defraud. So if my daughter uses my credit card and gets on Amazon, and I'm there and she logs in and she buys something, then she's not guilty under this, even though she's using my number, because she doesn't have the intent to defraud.
Your Honor, with all due respect, she's intending to defraud with respect to her authorization to use that card.
No, I'm sitting right there, and I said, go ahead and use it.
Well, then she has the authorization. There is no intent to defraud.
Right, but she's still assuming my identity.
And isn't the converse to your argument also true, that if we take out this, the commission of the crime by merely using the identity, the identifying information of somebody else, then doesn't the statute fail to cover a lot of very common crimes that one would think was definitely within the intent of this of this.
I'm not
of
sure
this
if I quite
statute.
understand Your Honor's question. I
Well,
mean,
let me give
go
you
ahead.
an example. An example is exactly this.
Right.
Somebody walks in to a store, attempts to buy goods, okay, using the identifying information, the credit card number of a third party, but doesn't pretend to be that person. And by doing so, gets that person involved in having their credit destroyed or other, consequences, which is exactly what the statute was intended to address.
Well, actually, it would be under the unlawful use of personal identification information, which would
Which
be
is a
covered under that,
misdemeanor, right?
which is different.
Which
But
is a
in that-
misdemeanor.
Which is a misdemeanor, but the point about it is that victims would still be eligible for various kinds of restitution. The person would be guilty of criminal possession of stolen property, criminal possession of forged instrument, as here, which are felonies. The point about it is that the people's interpretation on the face of the definition statute alone. I'm asking Your Honor to look at 19077. The categories there are very broad. The people are saying that if you use someone else's address on its own without their authorization to use that address, that automatically constitutes identity theft, and that doesn't advance a legislative's intent.
That's not exactly the way I read it, because I still think you need the element of intent. That's my problem with that analysis. Taking a step back for 1 second, I can't think of a circumstance where you would use someone's personal identifying information and that not be an assumption of the identity of that person. They seem to be co-equal. In other words, the way the statute seems to be written is you assume the identity, and in these three ways that you can assume identity, those are violation of law if there's an intent to commit fraud. And that's why Judge Garcia's example is the most common and the most straightforward one. And I'm having a hard time seeing how they're not co-equal. Tell me how they're not.
Well, Judge, Your Honor, the problem is 19077, which defines that third one, personal identifying information. So it's more than three. It's over 20 different categories of information, ways in which, plus a catch-all category, ways in which if you use any one of these types of information under the people's interpretation would result in the assumption of that person's identity. The problem is the way in which it was written. The legislature obviously wanted to.
What you're asking us, I guess I misunderstood in the briefs, is to strike that last by provision as being unconstitutionally broad, or only as to the last by on the personal identifying information, read an additional element of assumes identity into that subdivision only?
You would have, Your Honor, the reality is that you would have to, because if I use someone's address and I don't have the authorization to use their address, and unless the people have proven that I've assumed that person's identity, I wouldn't really be advancing the purposes of this statute.
I had thought your argument, and perhaps I was wrong here,
Right.
I had thought your argument was you needed that as a separate element for all of the other three. It assumes the identity was one element, and then you had to prove one of the buys.
Well, for the first couple, I mean, you can present yourself as someone else at a bank, and then tender an identification card, which then assumes that person's, identity, a false one, a false identification card. So let's say I go to a bank.
Any statutory rule or way of reading the statute that would let us do that?
Well, the issue is that it's the statutory rule that requires that the court interpret a statute in a way that effectuates legislative intent here. And I understand that oftentimes the presenting of oneself as another, or even the second one, would automatically result in the assumption of another person's identity. The real problem is that 19077 has such a broad list of types of information that if used alone do not necessarily result in the assumption of identity unless the people are held to their burden and required to prove assumption of
Problem
identity.
is, it's almost a fundamental conflict in your own argument, because you're saying the first two are that, and then you're saying the third one, the identifying information, you need something extra, where the legislature seems to have said it is A, B, or C. And so it's hard to follow how we could come to that conclusion.
I'm saying it's hard to follow, understandably, because that's the way that the legislature drafted the statute. The legislature swept in a whole bunch of conduct, some of which, if used on its own, like a social security number, would automatically result in the assumption of someone's identity. But it listed things like an address, telephone number, place of employment,
I'm sorry, then would
calling
it
card
depend
number.
on which subcategory of the definition, whether or not you needed to read the extra element in?
I think that's the ambiguity in the statute, Your Honor. That's the problem with the statute, which is that there are ways.
So your light is off, so let me ask
Sure.
you this. Let's talk about the facts in this case.
Sure.
Given that the defendant here uses the credit card,
Right.
but has ID with someone else's name on it and
Yeah.
two pieces of ID, right? The card has their other name because it's a fake card with someone else's number,
Right.
and a driver's license with that other name. Okay, so then the logical, if I were to adopt your approach and
Right.
your analysis, it strikes me that the logical extension of that is exactly what the people argue, which means the only way someone who's using the credit card fits under this statute is that they have to say absolutely nothing, right? Because then they haven't said, I am,
Right.
in this case, Craigie Johnson,
Right.
and I'm not. Or they have to, in some other way, disavow the card as theirs. That strikes me as not what the legislature is intending.
I think what the legislature intended was that, the use of certain kinds of personal identifying information, which were frequently happening at that time, if used, caused certain damages and harms to people. In this sense, where the victim's identity was assumed. In this case, what happened was, although he used the victim's personal identifying information, which was the credit card number, he did not put himself out there as Kelly Formoil. He did not put himself out there. His identity was not Kelly Formoil.
Well,
it was
but
Craigie
doesn't
Jonathan.
she, if it had gone through?
Sure.
If it had gone through, she's the victim either way.
She would be a victim of criminal possession of a forged instrument, which she was prosecuted for. She would be a victim
not
of
the
grand
defendant,
larceny.
I'm talking about the card holder, the
card
person,
holder. Yeah, she would be a
right?
victim. Absolutely.
She's
I'm
the
not saying that
victim
she's not.
whether he turns over the fake New Jersey ID
Right.
that's got some other name or
Sure.
not, right? If that store said, just put the
Yes.
card through, or if they said, if he hadn't sought $1,000 of
Right.
sneakers, he sought 499.
Right.
Under their policy, they just could have put in the number manually, and maybe it would have gone through, and maybe he would have walked
Right.
out with all those nice little sneakers and the hats and whatever else.
Yeah.
Right?
Yeah.
So she suffers either way. So if the legislature is seeking to protect victims from that, right, use of the credit card to purchase and affect your credit rating and so forth, your reading seems to me to undermine that legislative purpose.
Well, no, Your Honor. The legislature, look, if it didn't result in her assumption of identity, if it didn't result in any damage to her, then that's, or where Kerri Roberts was like, I'm running out there and I'm Kelly Formoil and that's who I am, and then it affects her credit report. If it did not result in that, which it didn't happen here, then the legislature wouldn't be protecting that. But the legislature was protecting her in the sense that, in other regards, that, Kerri Roberts here was found guilty of other more serious felony offenses, and she was definitely a victim of a stealing. But the question is, to call her a victim of identity theft, and to look more broadly, to call someone whose personal identifying information has been used, without the person's identity being assumed.
If I can ask one more
Sure.
question, I know you're later. But do you disagree that you say there's ambiguity, but
Right.
let's say the legislature actually intended what the people say the legislature intended. Is it your position they could not pass such a statute?
I mean, that's a difficult question. I mean, if the legislature didn't intend that, then that would be,
No,
that
if
would
they
answer the
actually
question.
intended to
Right.
capture the conduct
Right.
that you have described, is there any reason they could not do that?
Because there are practical situations, practical applications in the use of personal identifying information that ultimately would not advance the legislature's purposes, that they may not have thought about at the time that they enacted it.
Thank you, counsel.
Thank you.
Mr. Morrow?
A critical component of these statutes is the intent to defraud. So, innocent conduct that people engage in every day is not going to be swept up.
All right, so
and-
let me ask you this. Suppose I see a sign on Baskin-Robbins that says free ice cream cones on your birthday, otherwise $3. I walk in and say, today's my birthday. It's not, my birthday's in September. I have an intent to defraud. I've used somebody else's personal identifying information. Can I be prosecuted?
Technically, that conduct would have violated the identity theft statutes, but I think that you can.
No, I'm
point-
asking about the statute.
The identity theft statute?
I'm sorry, I thought you said anti-theft. Identity theft, yes, so
sorry,
it could be.
Identity theft statutes, but you can point to numerous examples with statutes where there's conduct that technically violates it, but whether it's, going to be subject to prosecution is another issue entirely. I'm an office employee, I forget my lunch, I know my coworker has a delicious sandwich in the fridge, I grab it without his permission and eat it. Technically, it's petty larceny, a Class A misdemeanor, but the police won't get involved in all likelihood, and the crime won't be prosecuted.
So, I mean, this turns on prosecutorial discretion. This turns on the prosecutor determining whether or not the prosecutor can establish these elements on reasonable doubt.
Well,
To distinguish between, I guess what you want to say, the innocent, what the legislature is not intending to criminalize, conduct that people may do every day.
the legislature is
isn't
not
there-
intending to
Can I get an
criminalize.
answer to that one?
Sorry.
Please.
The legislature is not intending to criminalize conduct that doesn't constitute an intent to defraud. The legislature chose to enact these identity theft statutes to combat a rampant problem. And with, most of the statutes in the penal law, you could find an example that, seems like conduct that might not be subject to criminal prosecution. And, it would likely depend upon the discretion of the police and the government. And just quickly, the legislature didn't require any harm to befall a victim in order to have a defendant violate the identity theft statutes. And ultimately, if
Can I just ask, no, your light is off, last question from me. Is it the people's position that in this fact pattern, when he's using a different name from the owner of the card, that the identity theft is related to the kind of fraud, the misleading information that's being perpetrated against that store and the cashier, or, in this case, the credit card company, American Express?
well, it's
Who is being deceived in that moment?
well, the statutes require only use of the victim's personal identifying information. So Ms. Kelly Formoyle's American Express account was used. There's no requirement that anyone in particular be deceived. And this case shows what happens in most credit card transactions. You go up to the terminal, you swipe your card. If it goes through, you walk out with the merchandise. It's rare for people to check that the name on the card and the name of the person using the card match. And here, that's what defendant knew. He knew he didn't have to use the victim's name, and he said, punch the numbers in, this is my card. It was the numbers that controlled, and that's why the legislature required that use of personal identifying information constitutes an assumption of
Is there a
identity.
difference, too, between a name or a credit card number or an address or a social security number and a date of birth, whereas the first four that I mentioned can be attributed to someone, whereas a date of birth can apply to millions of people. So you have to be able to identify a person whose identifying information was stolen, correct?
That's true, and I think
Or used or
well,
possessed.
you have also the requirement of an intent to defraud, and I think in those situations, the legislature was concerned about verification procedures that banks and other places have when you call and you give your name and they ask for your social security number, your date of birth, all this information. And it was those kind of crimes that they were concerned with, that somebody has a list of your details, as the defendant in this case had all of Ms. Formoyle's information, and they use that to defraud and commit crimes.
Is then assumption or assumes the identity of another mens rea or actus rea in this statute?
Assumes the identity of another. That would be the actus reus. The mens rea is knowingly and with the intent to
Okay.
defraud.
Thank you.
Thank you, counsel.
Thank you.
Number 43, the people of the state of New York versus Terry J. Rush.
May it please the court. My name is Dina Mueller-Funke, and I represent the appellant Terry Rush. Before I begin, may I reserve 1 minute for rebuttal?
1 minute rebuttal? Yes.
I'd like to echo the words of counsel for Mr. Roberts, but temper them a little bit by going back to this idea that was bounced around, that the third prong of assumes the identity is being treated differently than the first two. I don't think it is. I think all of them require something in addition to proving that the person presented as, acted as, or used the personal identifying information. And that additional thing that needs to be proven is that that person, in doing so, in fact, assumed the identity of the other person.
But the argument is that any one of those acts are or constitute assuming the identity. Presenting yourself as another person, acting as another person, or by personally using somebody's ID, you are assuming the identity. That's the argument as I understand it.
Right, Your Honor. We disagree, obviously, that assumes the identity is not a separate element. But I think the point is that the people are assuming that if you present yourself as somebody else, you have assumed the identity automatically.
Let's ask that a different way. So one of them is you can do it by presenting him or herself as that other person. What, in addition to that, would you need to assume the identity of another person?
I think you need to prove that you actually assumed the identity of
Yeah,
that
but
person.
that's what the term says, but what thing could you possibly show in addition to presenting yourself as the other person or by acting as that other person that you assumed the identity? Let's say presenting yourself as the other person. What is the additional thing they would need to show that you assumed the identity in addition to that?
That there was, in fact, a taking on of that identity. Because if you don't take on the identity, then you're just
But
using...
Isn't that by I presented myself as that other person? I don't understand what the additional factual proof would be. Give me an example.
I think there's an example if you go to the Barden case, right? It was clear to everyone at the hotel that he was not the card holder, and therefore when he was saying, charge it to my card, he wasn't assuming the identity. What if he had said, I am the card holder, charge it to my card? Would that have changed the fact that everyone knew he was not the card holder? He may have presented himself as the person, but did he take upon himself that identity? I think in all three of these factors, you need to show that the person is, in fact, the definition of assumes. It's simple. You take upon oneself, and unless you're taking upon the identity of somebody else,
If you're acting or presenting yourself as the other person, I think that case you referenced, a different case and very different facts about the card. But if I go into some place and I say, I'm Joe Smith and I have, what else do I need to say? And I'm not. What else do I need to show that I assumed the identity in addition to that? Like, give me a scenario. In that case, what else would I need? What would the people need to prove?
I think you need to prove that you're appropriating the identity. And if I could kind of swing you to the third prong and maybe clarify it a little better, I think this is exactly why the decision was wrong in Usan but right in Destin. So in both of those cases, the defendants are trying to cash or deposit forged checks that are payable to themselves. They're using their own identification cards, they're signing their own signatures, they're trying to deposit into their own account, and they're being charged with identity theft based on the fact that they used the remitter's personal identifying information. Well, of course you did. Everyone who cashes a check has to use the remitter's personal identifying information, but what is being lost is that they weren't appropriating that information onto themselves.
Again, it seems to me you're making the argument that counsel made already, which is we should treat the third prong differently because you can't distinguish the first two prongs. And your only real examples are in the third prong, which you think there should be something else because it's too broad. And I find it hard to come up with that type of principled analysis of this statute.
Even the second prong, I think, lends itself to some examples. You're saying you're going to act as somebody else. I may act as somebody else, but if I'm unconvincing and no one believes that I'm taking on the identity of somebody else, have I assumed their identity? I think you have to prove something else, and I think that's what counsel's point was about how...
That relates to the effect on the other party. That doesn't relate to we talked about actus reus, mens reus, but that's not the act. That's whether you've succeeded in doing it or not.
Well, then maybe you would only have an attempt. If you're not successful in appropriating somebody else's identity, I don't know that you haven't assumed their identity and you haven't stolen their identity. What I really want to focus on...
Counsel, I understand what you're trying to argue, but are you taking the position that the legislature could not do this? You may disagree with this choice. You may disagree that the legislature has picked a category that is very broad and so forth. But you're not taking the position that the legislature could not do this. And if that's so, doesn't the legislative history tell us that this is exactly what the legislature intended?
Your Honor, I'm not taking the position that they couldn't define personal identifying information the way it is, but I'm saying that if you don't temper it with assumes the identity, which is the next point I want to make, then you get these absurd results where you're calling a husband depositing his wife's check an assumption of the identity. It's not an assumption of the identity. It's just a use of personal identifying information. They're separate. The people say that intent...
Yes, that's true, but they might not be guilty of the crime, right? Because they don't meet the other elements of this crime.
Supposedly because of intent, but we would argue that it's this independent element of assumes the identity that tempers the statute. That's what That's where you tie the victim's identity to the defendant's actions.
Does Alec Baldwin sometimes present himself as the President of the United States?
Yes, certainly, Your Honor, an act.
Appropriated his identity?
We could only wish, but okay.
Yeah, I think acting is a good example of where clearly you are acting in the way of another person, but how can we say that they're assuming the identity?
No, but how can we say they're committing identity fraud is really the question, because they have no intent to defraud, but they are assuming the identity. Someone goes on, they pretend they're Mark Twain, or they assume the identity for a performance. Sure, they do, but it's not an intent to defraud.
So I would disagree then, Your Honor, that they're assuming the identity, and I disagree that intent alone can temper the statute. Going back to the example where Judge Fahey said he's going to give his wife a check to deposit while he's in Albany, what if she goes in to deposit that check and it's her intent to defraud the bank? Subjectively, that's her intent. It doesn't matter why. Has she now guilty of identity theft? That doesn't make any sense. She never assumed the identity just because she used his personal identifying information. And that's a point that I really want to make about Ms. Roberts' case, and I think it's different, Ms. Rush's case. I think it's very different from Mr. Roberts, is that what Ms. Rush did with the personal identifying information of the victim, in that case, Mr. Lawhorn, didn't require that she was Mr. Lawhorn. All she did was deposit a check that was payable to Mr. Lawhorn into an account that bore the name of Mr. Lawhorn.
She used his name to defraud the bank.
No, she didn't. What did she defraud the bank of? She may have had intent, she may have been defrauding as to the validity of the
She
check.
put the money in so that someone could take it out. That wasn't the person whose name she used.
Respectfully, Your Honor, I don't think that that's what the legislature is getting at. The intent to defraud is of defrauding about the identity of who you are. And she didn't say, I am Lawhorn. She didn't act as Lawhorn. And just because she used his personal information in a lawful way, the same way.
But doesn't it get at what the intent of the statute is? Because Mr. Lawhorn was first, or at least could have been, suspected of being the person who stole the checks and forged the checks, and could have been subject to criminal prosecution, and could have been subject to all kinds of things, which is exactly what the statute is aimed at preventing.
I disagree, Your Honor. All she did was deposit checks into his account. In fact, there's actually no harm to the victim here. This is another.
Subsequently withdrew them, correct? Withdrew on them?
That's not actually. That was never proven. It was never charged. It's implied and it's been alleged that she later withdrew the money, but it doesn't matter. I don't think in this circumstance you need to be looking at what conduct happened after. Whether she assumed the identity was in the moment that she used his personal identifying information. And because she was just doing what everyone else is able to do, use somebody's information to put it into their own bank account, I don't think her conduct later has any bearing on whether she's assuming
The
the
bank
identity.
itself,
That's not
the bank
evidence of her
itself.
intent to defraud? That's not probative evidence of her intent to defraud?
I think the intent to defraud is related to the identity. Are you intending to defraud somebody as to your own identity? And she wasn't. She didn't appropriate his identity in any way by using it on the checking deposit slip and putting it into his account.
The bank itself doesn't treat someone who comes up to the teller and deposits someone else's bank, the check as presenting themselves as that person, correct?
No, in fact, the testimony was very clear, pages 120, 121. The prosecution's own witness said, no, we don't check ID when you deposit. Nobody cares who puts money in.
Counsel, do you care to spend a moment on the second issue?
The thereby issue? Sure. I think that if this court were to determine that assumes the identity is one and the same with use of identifying information, you don't have to, you can still reverse Ms. Rush's conviction because she didn't thereby commit the Class D felony. So I think we're arguing the first part of the statute's ambiguous, but the second part is
Can
not.
you address the closure of the courtroom?
Sure. Your Honor, if I could only say one thing about the closure, I would
Yeah,
say.
because your light went off.
Right, the word Gupta. If you give me another 25 seconds, I would explain that in that case, the court held that if there's an intentional, improper closure of the courtroom that lasts for the entirety of jury selection, that is not trivial per se. And that's exactly what you have here. It was an affirmative act.
Do we have to, if there's support in the record for the court's finding that it was not closed for the entirety of jury selection, that it was only closed until the jurors were seated in the box, don't we have to accept that finding of fact?
I think it was, I think that it's an improper application of law to say that the court was reopened because it's only reopened by an affirmative act on the court. And if you look at the record, this goes to the third point I wanted to make. It was an improper closure because the Waller factors weren't met, and then it was for the entirety of jury selection because the court itself took no affirmative acts to reopen the court. Even if
So
you...
are you saying that if in this case, the gentleman in question was waiting outside the door, the judge never said to the court officer, please go open that door, but the court officer took it upon herself to do so, the gentleman walked in, we would still have a violation of the right to a public trial because the judge didn't tell her to do that?
I think even if you impute the deputy's conduct to the court and say that was the court's action, I think they fell short of their obligation to reopen the court. There's a heavy burden on the court when they close themselves to the public to reopen. And when they specifically include somebody and say, we intend to come get you, they need to follow through with that. So they either needed to post a guard at the door, make an announcement in the hallway, put a sign on the door, or do something more than make a half-hearted attempt to look for him in the hallway and then give up on it.
Thank you, counsel.
Thank you.
Mr. Gross?
Good morning, or afternoon, and may it
Good
please the
afternoon, sir.
court. Dan Gross on behalf of the people, Monroe County District Attorney's Office in the matter of the People versus Terry Rush. I'd like to begin by discussing the proper interpretation of the identity theft statute and why this court should adopt the Fourth Department's interpretation of it, and then, time permitting, address the courtroom closure issue. The unique harm of identity theft is not that it allows a criminal to impersonate another, but that it allows them access to their financial and credit information. And that's exactly what happened in this case. To that end, the legislator defined assumes the identity, admittedly very broadly, to include the mere use of personal identifying information, as well as presenting yourself as another and acting as the other person. Assumes the identity of another, although it's broad, is tempered by, as this court has recognized, the mens rea of the crime. I would analogize this crime to possession of burglar's tools or criminal possession of a weapon in the fourth degree. Although I may be walking down the street with a crowbar or a billy club, that in and of itself is legal. However, once I have the criminal intent, then it becomes a crime. In this case, the harm which the statute aims to prevent was present. Mr. Lawhorn's reputation and credit history were affected by, or could have been affected by this.
But the actual act is one that happens all the time, and the bank, there's testimony that the bank indeed sees no problem with this, and recognizes that people do this all the time, doesn't object to it, only asks for ID when someone wants to withdraw cash. That's their concern.
Right, however.
How could it be that the legislature really is intending to cover this kind of conduct?
Well, these were stolen checks that were funneled through Mr. Lawhorn's account. So although the deposit may not have raised too many red flags, and that is a very lax policy that they had, and I think was part of the reason the Barden decision came out the way it did. The hotel had a very lax, apparently very lax policy. However, the harm was still the same. Mr. Lawhorn's identification was used to funnel this stolen money into his account and then surreptitiously withdrawn over 3 days over the course of November. I would submit to this court the plain language of the statute couldn't be clearer.
So if I find a check that's just like Mr. Lawhorn's on the subway, and it says deposit to an account number and it's signed, and I conclude that somebody dropped it, and I go to the bank and say, I found this on the subway, here it is, am I assuming that person's identity? I know I don't have fraudulent intent, but I'm not asking that.
Yes, under the statute, you would be assuming their identity. However, again, that's just the actus reus. You have no intent to defraud. No crime has occurred there by the mere deposit. But that's what distinguishes this case. Miss Rush was surreptitiously withdrawing money.
Well, you're not saying that if I walk in with Mr. Lawhorn's check and I say, hi, I'm Leslie Stein, I'm not Mr. Lawhorn, but I want to put this in his account because, you know, it apparently is where it intends to be. That's not assuming the identity, is it?
Under the statute, it is. Again, it's not an impersonation statute.
So you can't negate it by some affirmative act?
I believe that would result in an absurd loophole where if I go to Wegmans and there's a self-checkout versus a cashier, and I use the same credit card, if I go to the cashier and say, this is not mine, however, I have authority to use it, I'm not assuming the identity, versus if I go to the self-checkout and use it, the same harm has occurred, albeit this.
But then again, that goes to what I was asking in the prior case. Isn't then this language superfluous based on the people's construction?
I would submit it's a term of art. Otherwise, to read assumes the identity as requiring an impersonation element, you could get rid of the mere use of personal identifying information. It just couldn't be accomplished unless you were presenting yourself in one way or another or acting in one way or another. So personal identification information would be rendered redundant.
So you mean under that analysis, you're always going to fall under the first two categories,
Correct.
and the third one drops out?
Correct. And in addition to the plain language, I would also point to section 190.77, which is the definition section of personal identifying information. The last clause of it says that any piece of personal identifying information can be used by itself or in combination to assume the identity. So I think there's support there for the Fourth Department's interpretation of this statute. In addition to that, the legislative intent has been talked by all of my colleagues already. I would submit that is.
But let's go back to that definition. Can be but need not be. So isn't that still the problem with this, potentially with this statute, the identity theft statute? Because not always.
Right, not always, and I think that goes to show that you can accomplish assumes the identity through impersonation, not merely through using personal identifying information. It does say you can use personal identifying information, however, it says it may be used alone to assume the identity. So I think that clarifies the interpretation of this statute.
But I think Judge Rivera's question is, because it says you can use one or some in combination, the thought that you might need to use some in combination means necessarily that there are going to be times when using just one piece of information isn't enough. And so then figuring out when one isn't enough and more are necessary requires something more than just the use of the information, which maybe takes us back to the assumes the identity of as actually a meaningful term.
I guess my reading of the statute is different. My reading is that maybe used in combination prevents a prosecutor from charging a distinct count of identity theft for each piece of personal identifying information which can be used. So someone's name and address and checking account number may all appear on a check, but that is still only one count of identity theft under my interpretation of the statute. If the panel is all right with it, I'd like to move on to the definition of thereby.
Please.
It's very difficult to argue to a learned panel about what a word means, but I would submit that thereby in this statute just means that any of the predicate offenses, whether it's larceny or criminal possession of a weapon, or criminal possession of a forged instrument, needs to be accomplished using the same means of the identity theft occurs in. So in this, for example, in this case, the personal identifying information, again, the name was the way in which Ms. Rush was able to utter this check. A correct name still needed to be included on the check in order for a deposit to occur. Otherwise, there is no crime. Moving on, I'd like to discuss the courtroom closure very briefly. The courtroom closure, I would submit under these facts, calls for the triviality exception to be adopted. This court
Have we
has.
ever adopted that exception?
No, it has
This would be
been
the first
referenced.
occasion on which we do that, so?
Excuse me?
This would be the first occasion on which we do so?
Yes, expressly.
Do we need to do that, or can we just say that, that there was nothing, no part of the trial was going on when the jury was being seated?
Right, I think that argument can occur in the alternative, that this was, I guess, a de minimis violation, although the judge ordered Mr. Granville, I believe his name is, out of the courtroom. According to the record, nothing occurred. It was just so the jurors could be moved into the box, and then Mr. Granville could come back in and observe jury
Can we
selection.
just explain, what happened after the person left the courtroom? The
You're
prospective
correct.
jurors come in, and then what happens?
The respective jurors come in, and then they're called into the box and seated, and the preliminary instructions occurred, and
The
then,
judge did start instructing.
correct.
The respective
There
jurors?
were instructions given to just, in my experience, it's more of identifying the parties, maybe
Is it
reading
the
the
people's
indictment.
position that the judge had decided that during those instructions, people could not be in the courtroom?
Yes. Oh, well, no, excuse me. I apologize. No.
Thought you might want to.
No, that wasn't the court's decision. The court just wanted to move the jurors to the panel box so that seating could occur for any spectators, and I believe Mr. Granville was the lone spectator here.
Your position is that the courtroom was open before the court started instructing the jurors, isn't it?
Correct.
Am I understanding that correctly?
Yes.
Okay.
When the judge instructed Mr. Granville, according to the record, he said, "You need to step outside for a minute just so I can move these people here and create seating for you."
Right, I think the question here is, when did the courtroom actually get reopened?
Well, I think it was all in the same instruction. There was no affirmative act where the judge paused everything and reopened it. The judge, by his instruction, made clear that although there may be a closure, it's only going to be momentarily. It's not in the constitutional sense. Just wait outside and you can come back in.
Where was the court clerk at the time?
The deputy
Yes.
who retrieved him?
Yes.
Yeah, there were two deputies.
Well, people are walking in while they're getting seated during these preliminary instructions. Inside, outside, looking for people, what is
I
the
believe the
person doing?
deputy who went to retrieve Mr. Granville went to get the jury panel and then came back in with the jury panel before going out to get him.
At
And-
what point? After the instructions?
No, after the
So once they
veneermen
came in and were in the
seated
box, went out?
Correct.
Okay, thank you.
Thank you.
Thank you, counsel. Counsel?
Very quickly, without getting hung up on it, I just want to address that last point about the closure. I don't think it's clear on the record exactly when she goes out, and her testimony was not even clear exactly when she
Let
went
me
out.
ask you this, Would it be an unconstitutional closure of the court if the following happened? This is my hypothetical. So you've got, the prospective jurors are called up, they're starting to walk in. I show up, I want to go into the courthouse, because I just want to sit and observe what's going on in that courtroom. And the clerk tells me, just a moment, these people have to walk in. As soon as they walk in, you can walk in. Is that a courtroom closure?
If you actually were able to walk in 30 seconds after they took the box,
Correct.
I think that we would be closer to triviality, but I don't think that the record discloses that's what happened here.
Is that the standard we should apply? Are you advocating that we adopt that particular?
I'm advocating that you don't adopt the standard of triviality at all, because even if it was a trivial closure, I don't think this court has to agree.
So how in my hypothetical is that a closure? Even though you're saying, well, it may be trivial?
Yes, it's still a closure.
Because
It's close to the public.
The clerk is, what, controlling the flow through the doors?
That's
And says,
correct.
just wait one moment, I've got to let these people walk in?
If you're preventing the public from going into the courtroom during the proceeding, I think that's a closure. But if,
So if I showed up and said, I want to walk in before this person, they have to let me walk in? Just a flow of people into the room.
if it's purely administrative, which it wasn't here, then maybe it's not a closure.
How is it not administrative here if the judge is saying, I need to get these people in the seats? There's no room, everybody's standing.
I don't think that it was purely administrative because, first of all, it's not a justification for closing the courtroom, but it wasn't just until the 21 people take the box. I mean, it's very clear on the record when those 21 people have sat down, page 548, and then there's nothing on the record about what happens afterwards. And in fact, actually on page 642, the judge says, oh, is there room in the back now? For those 96 pages, like what's been going on in the court, and he's not sure if there's room in the back. Has Mr. Granville even been, has anyone searched for him yet? We don't really know where this happens, and there should have been something on the record immediately after if the courtroom's being, if
Did
you're-
they have to go search for the person?
I think you do. There's an affirmative burden, there's a burden only, I don't know which case it is, but I know I cited and it says that a courtroom is only reopened by an affirmative act, in the same way it's only closed by an affirmative act. And I know I'm out of time, but
Yes,
can I
but
make
does
one
that
point?
include having to look for the person?
I think it includes a burden beyond what search was done in this case. And I know I'm out of time, but if I could make one point back to the identity theft issue. I don't think that the court even needs to get embroiled in all of the arguments we made today. I think the question is it ambiguous? I think it clearly is. You have 3 cases in the First Department and 3 cases in the Fourth Department that come out differently. Reasonable minds are differing. If it's ambiguous, the rule of lenity should apply.
Thank you.